Our argument this afternoon is Peter Spence versus Oracle Senior Home Care LLC and ESIS. Counsel, you may approach.
Good afternoon, Your Honor. May it please the Court, Jay Levy and R. Corey Schnepper on behalf of the appellant. I respectfully request 4 minutes for rebuttal.
So noted, Counsel.
Thank you, Your Honor. Your Honors, this is an appeal from a final order denying a request for attorney's fees made pursuant to Rule 60Q 6.120 per subsection 4, dealing with the denial of a motion for a summary final order. The procedural history that's relevant to this particular case is fairly simple. A claim was filed, I believe, in June. Early on, discovery was requested. There was no discovery provided. Instead, both employers and their carriers filed motions for summary final order while discovery was outstanding. As to the first motion filed by Oracle, we filed affidavits in opposition to those summary final order motions, and we maintained that A, there was an issue of fact, and B, that the discovery was outstanding. As to that motion was denied by the JCC without a hearing on the same date that we filed our response. The second motion was filed by PBS, Paychex Business Services. We responded to that motion saying that we had outstanding discovery, not the least of which was please produce a copy of the workers' compensation insurance policy. And we cited a case of Cujo in response, indicating that when discovery is outstanding, you cannot grant a motion for summary final order. Again, the JCC denied the motion on the same day and citing the case that we cited in our memo, and said that it is inappropriate to move and to obtain a summary final order when discovery is outstanding. Those are the basic facts. We then moved for attorney's fees pursuant to Rule 6.1204, subsection 4, which indicates that when a motion for summary final order is denied, attorney's fees shall be awarded if the court finds that the motion violated Rule 6.125 paren 2.
Counsel, what's the basis for saying that a party has a grounds to make a motion under that rule as opposed to the judge in his or her own discretion?
Judge, I don't read that rule to say that a party cannot make the motion. It reads to me, as I understand the rule, that anyone, a party or the judge, can award fees.
Well, then why is it necessary to have it in that rule anyway if there's 60Q-6.125?
I'm sorry, I didn't hear the first part of it.
Well, there's a sanctions rule,
right,
which is in part cross-referenced by 120. But I don't, if by your argument, then there's really no reason to have 120 if there's 125.
Well, no. The rule is very specific and was drafted for a reason. 6.125 is the general sanctions rule when applying across the board to all workers' compensation pleadings. This is a very specific rule designed to encourage people only to file motions for summary final order when it's appropriate to make them for that kind of a motion to be made. In this particular case, it was procedurally inappropriate at all times for these motions to be made because discovery was outstanding, and this was at the inception of the case. My position might be different if there was no discovery outstanding or if it wasn't made at the inception of the case. But it's the claimant's position here that the rule is designed to ferret out issues of fact to see if there should be a trial. It is not designed to be a discovery suppression motion to prevent one from discovering the facts to lead to a claim. That seems to be what the modus operandi of the employers and carriers in this case was, but that is not the purpose of the rule. We don't...
But isn't the purpose of the rule, especially under 125 subsection 5A, it's deterrence only?
I'm sorry.
The purpose of any of this is deterrence only, right?
Well, the purpose of...
and that's what the rule says, is deterrence.
But I don't want to go to 6.125. The applicable one is 6.125.2. We made this motion under 6.120 as the appropriate motion within the meaning of the rule that when the motion is denied, attorney's fees shall be granted. The only portion that the test is provided for in 6.120 is whether the motion violated 6.125 paren 2.
Sure, but it also cross-references subsection 5 and 6, which talk about the actual process and the purpose of a sanction, which is deterrence and not, and it's supposed to be set to ensure that the conduct doesn't repeat. The reason, before you concede that you're under one rule versus the other, let me tell you why I'm asking. I'm asking because I'm trying to understand what your client's right is that you're seeking to enforce on appeal.
Well, we are seeking to enforce the fact that we were required to respond to the motion, to engage time, and as 6.1252 says, it says that A, if it is presented for any improper purpose, such as to harass or to cause unnecessary delay or needless increase, or B, the claims, defenses, or other legal contentions therein are not warranted by existing law. And that right is the right that we seek to enforce, that we were required to spend time and to do things in this particular motion in response to the motions for summary final order. If I was to analogize to the rule allowing for attorney's fees, if the claimant's attorney has to attend to a deposition, the right to the fee comes with attending the deposition, even if there's a voluntary dismissal of the claim later on. Situation here is analogous, it's not identical, but in this particular case, the right to attorney's fees accrued to determine the applicability of 6.1204 when the claim was denied. So yes, the benefit that we're seeking to enforce here was the entitlement to fees, and that's what the motion indicated under 6.1204, that we were seeking entitlement to fees because we had to respond to a baseless motion for a summary final order under 6.120. And when I use the word baseless, I use it very narrowly here to say procedurally inappropriate because it could not have been granted. It was doomed to failure at the time it was filed because of the pendency of discovery. And again, the thrust of the claimant's position here is the motion is designed for a purpose, the 6.120 motion, and our motion was not for sanctions. Our motion was to determine entitlement for attorney's fees because the summary final order had been denied. But the purpose is to ferret out whether there are issues of fact for trial. It's kind of hard to determine that, and that's why there are all these cases that say, whether it be in the civil context for summary judgment motions or in the workers' compensation context for motions for summary final order, that you shouldn't grant this motion when there's discovery pending, and in this case, initial discovery pending, because how are you ever going to determine whether there's an issue of fact if you cut the claimant off from the right to determine, to obtain his evidence? And that's why this motion failed. That's why the judge himself ruled that these motions could not have been granted, particularly with regard to the PBS motion, because the judge determined that there was discovery pending, and therefore you could not grant this motion. So that's the theory of the claimant's case.
Counsel, if I may digress back to the jurisdictional issue that has been raised in this case. Since the claimant dismissed his petitions after filing his motion for sanctions, how do you respond to the EC's argument that once you dismiss your petitions without prejudice, you abandon your claim, resulting in no jurisdictional issue or controversy to be determined under the Workers' Comp Act?
Thank you for that question, Judge Lewis. I would respond by citing a case that Your Honor, I believe, sat on the panel for, Murillo versus Tri-State Employment Services at 925 Southern 2nd 376. In that case, there was a voluntary dismissal, and then there was the hearing on attorney's fees. This court held, quote, according to Florida law, after a voluntary dismissal by the plaintiff, the trial court does have jurisdiction to award attorney's fees where the fees are authorized by statute or a contract between the parties. The court, in reaching that conclusion, cited from a 4th District case, Stewart Plaza Limited versus Atlantic Coast Development Corp., 403 Southern 2nd 1136. In that case, the court held, just like this court held in Murillo, we hold that a voluntary dismissal by plaintiffs, the trial court does have jurisdiction to award attorney's fees where the fees are authorized by statute or contract between the parties. Here, it wasn't a statute, it was a rule, but I don't think it's any different. The this court has held clearly that jurisdiction continues to adjudicate the attorney's fee issue, and we had asked the court to adjudicate the attorney's fee issue. So it is our position that Murillo controls under this court's precedent and that the court had jurisdiction to determine the fees. And therefore, if the court had jurisdiction to determine the fees, it had jurisdiction to enter the order. When it denied it, it became a final order for purposes of this appeal. I hope that answers Your Honor's question.
And who did the claimant's motion seek fees or sanctions against in this case?
In this case, it sought sanctions against both the parties and the attorneys. Okay? And I know that there is an issue that's been raised as to the enabling statute and whether or not you are entitled to award attorney's fees against a party.
I'm not sure I heard you. The motion sought fees against the parties as well as
I
the
believe
attorney.
it sought, you know, now that I think about it, Judge Lewis, I believe it sought attorney's fees against the parties, not against the attorneys. That's the way I remember it, but whatever the motion says, it says.
That means against the employer and the carrier.
Yes, sir. Okay, and and the argument is that the enabling statute raised by the appellees in their brief, 440-33, I think is the statute that they cited, does not allow for an award of fees against a party, only against the attorney. But the enabling statute for the rule 6.120 is not 440-33, it's 440-45, and you can read that rule as I indicated in my reply brief. It's broad enough to allow for procedural rules such as 6.120. So finally, the last point I wanted to make here.
Well, counsel, if your client had not taken a dismissal and it proceeded with the case, and at the same time your client took an appeal of the denial of your motion, would that have been an appealable final order?
If the case proceeded on and the attorney's fees were denied, no.
Well, in the middle of your case, while it's proceeding, you take an appeal of the denial of your motion for fees.
No, I think if the case had gone on, then it would merely be an interlocutory order because the case proceeded. But here, once it became a final order capable of review by this court because of Murillo and the indication that even if you take a voluntary dismissal, the attorney's fees claim goes forward. But to answer specifically your question, if the claim is going forward and the fees are denied, it's a mere step to the final judgment, and you'd have to wait for the final order to appeal.
So you think that a party can create a final order if they want an answer to their question? They can take a voluntary dismissal without prejudice, take an appeal of that otherwise non-final order, get a ruling, and then come back and refile the case?
No, I don't think a party can create jurisdiction. I think jurisdiction is vested by the rules and procedures in the statute. I'm saying that in Murillo, this court indicated that's an appropriate procedure and that this court has jurisdiction. And so, no, I don't think we're creating it. I think we're just following what this court held. I see my time is almost up, and I think I'm into my rebuttal time.
Just before you sit down, counsel, how do you respond to the argument that the relevant statute and our rules in this case does not authorize the award of fees as a sanction against the employer and or the carrier?
Well, I think their argument was it doesn't allow for fees against a party because the enabling statute they contend was 440-33, and under that statute you could only get fees against the attorneys. We say the enabling statute is 440-45, and that the language of 440-45 is sufficiently broad to allow a fee against the attorney, against the party. I'm sorry, and if I could find the rules, it says, quote, "The Office of the Judges of Compensation Claims shall adopt rules to carry out the purposes of this section. Such rules must include procedural rules applicable to workers' compensation claims resolution." And I think this is a rule that's applicable to workers' compensation claims resolution. And I think that otherwise you have to invalidate the rule, and I think we have to look for any potential construction that would validate the rule and render it appropriate. And with that, my time's almost up.
If you have other questions, counsel, I will extend your rebuttal time by an additional 2 minutes.
Thank you, Your Honor. So we respectfully request that this court reverse the order and remand it back for a determination of the amount of fees.
Thank you. And since we extended the counsel for the claimant's time by an additional 2 minutes, we'll extend your time by an additional 2 minutes as well, counsel.
Thanks, Judge. May it please the court. My name is Bill Rogner, and along with trial counsel Andrew Bora, who's sitting back there in the audience, I represent Aricall Senior Home Care. I'm going to be sharing my time with counsel for Paychex, Ms. Connor, who's at counsel table. I'm going to roughly try to split it in half, and I know that I'm the one that has to watch the clock, Judge. I'll take care of it. Okay, your questions, Judges Lewis and Tannenbaum, hit the head on the nail. This is a jurisdictional question. You told us in the Phillips case, Phillips was a sanctions case that addressed 440.32. It's not 440.33. The statute's 440.32. That's where our sanctions are. There was an interaction or a disagreement between 440.32 and the language in the 60Q rule, 60Q-6.125. And the court said, look, a procedural rule can't create substantive rights. The statute creates the substantive rights. And a procedural rule, as we know, cannot expand, modify, or contravene the rights created by statute. So the key here is what sanctions are authorized by statute. And Section 440.32 authorizes the judge to sanction lawyers. The only sanction can be imposed against the attorney. In fact, the statute says you can't even recoup it from your client. That if it's sanctionable behavior, the lawyer is the one that is sanctioned, okay? Then we get the 60Q rule that was adopted. And the 60Q rule also allows sanctions to be opposed against lawyers, but it permits the same sanctions, attorney's fees as a sanction, to be imposed against the parties.
But was this rule challenge preserved before the JCC, though?
It was not.
Okay, isn't that a problem?
I don't think it's a problem because it goes to subject matter jurisdiction. So what the judge was asked to do, he had no legal authority to do. It was impossible for the judge to award fees against a party under the 60Q rule because he had no jurisdiction to do so. His jurisdiction to act has to come from the statute. And Judge, you've told us this many times. It's many cases. Once the claimant files a voluntary dismissal, the JCC is divested of jurisdiction to take any further action in the case. Now they cite—
The claimant relies on this court's opinion in Morello versus Tri-State Employment Services in support of his argument. Can you distinguish that case?
Easily. He quoted the language that I'll quote for you. In Murillo, it said that the judge maintains jurisdiction if the fees are authorized by statute. Doesn't say if the fees are authorized by an invalid rule. It says if the fees are authorized by statute. There's only one place that fees against a party are available in Chapter 440, and that's 440.34, which is not implicated here, because they never won their case. They call, by the way, our motion for summary final order frivolous because it was filed too soon, but it was legally and factually correct, which explains, I submit, why they dismissed their claims. The claims remain denied. The claimant's never gotten any benefits and is never going to get any benefits because they abandoned the case, right? So once the JCC or once the claimant took the decision to take a voluntary dismissal of all the petitions, the judge is done. Now, there are some limited statutes that give the judge the right to act in following a voluntary dismissal. One of them is 440.30, which allows the judge to award fees if we decide to take a deposition with no claim pending. That's there. There's another provision that allows the judge to order the claimant to sign Social Security disability releases. And you've got cases that I cite in the brief that explain why a judge would have jurisdiction in those limited cases, those limited situations following a voluntary dismissal. What you have to find for the judge to hang his hat on, the jurisdictional hat, is you have to find a statute that authorizes the action. That doesn't exist here. You also directed us to file supplemental briefs on your jurisdiction to review this case. And Judge Tannenbaum, you asked a question that I think sums up my position in this case. You can't create an otherwise non-final, non-appealable order or convert that order into a final order by abandoning your claims and saying, okay, well, it's a non-final order, but I'll just dismiss everything. I'll make it a final order and I'll take it up on appeal. So this is like a civil case. So in a civil
Well,
case—
he didn't abandon his claims. He just suspended them temporarily, right?
Well, I don't know how temporary it might be, but that is a good point, Judge. That I guess he has the capacity to refile, but I know this. Since the day the dismissal was filed, if you look at the docket, there's not one bit of activity on that docket except this stuff right here, okay? That's the only thing that's pending. But what I liken this order that's on appeal right now to a review of a denial for fees, pre-judgment denial for fees in a civil case. We know, I cite the cases, the Redbird Laundry case is one, that says a denial of a pre-judgment motion for fees in a civil case is not reviewable. It's not a final order. A denial of a post-judgment motion for attorney's fees would be reviewable. In this case, they have every right, as you point out, Judge Tannenbaum, they've got every right to refile their claims. Refile their claims, get to a final hearing. If they lose, or if I win and they want to take a cross appeal or whatever they want to do, they have the right to have that denial of their motion for sanctions reviewed at that time.
Right, and wouldn't it be helpful for a reviewing court to know what the ultimate outcome of that case would be when assessing whether the original motion was sanctionable in the first place?
Absolutely. If what happened was they refiled their petitions, it went to trial, and the judge said, I find these defenses are frivolous, they're outrageous, of course this is a covered claim, then that would support their argument that us filing the motion was frivolous in the first place. And you know, I'd like to point out one other thing about this close of discovery or completion of discovery thing, okay? We have rules that they're relying on, and those rules have certain timing with regard to both discovery and the motion for summary final order, okay? The rule says that the motion for summary final order cannot be filed less than 45 days before the trial. That's what the rule says. When does our discovery end? 6.113, which governs discovery, says our discovery does not end until 10 days before trial. So if they're right, I couldn't file a motion for summary final order in any case because the discovery period goes until 10 days before trial, while the cutoff for filing the motion for summary final order is 45 days before the trial. So here, their argument about discovery not being complete, that is a great argument to oppose a motion for summary final order, right?
Didn't they make that argument?
Did they make the
They
argument?
made that argument.
Yes, absolutely, right? And if the judge, as the judge did here, says, okay, I accept that you want to do more discovery, that's reasonable, you need to do more discovery, I'm going to deny your motion. That doesn't make the motion sanctionable. All that means is that now we're set for trial, and we're going to go have our day in court and have it tried on the merits, except that never happened here, because immediately after they won their motion, they dismissed their petitions and they never refiled them.
Did the claimant, in the responses to both motions, did the claimant mention anywhere that the fact of filing a motion for summary final order is frivolous, baseless, illegal?
No, sir.
Or the underlying legal argument about leased employees, whether that was just outrageous and a non-starter?
Nope. They did not, certainly not with regard to my client's motion, but they filed a standard response. The judge looked at it, entered a standard order, and we thought, okay, well, now we'll go to trial. But it didn't happen that way because they dismissed everything and started moving for sanctions. So, Your Honors, I don't want to take any more of Ms. Connor's time, so if you don't have any further questions, I'll turn it over to her.
Thank you, counsel.
May it please the court. My name is Jessica Connor, and I represent the employee leasing company, Paychex Business Solutions, also referred to as PBS, Zurich American Insurance Company, and the servicing agent ESIS, collectively referred to as the EC. In reviewing the JCC's decision to deny the claimant's motion for sanctions, this court must affirm if there is any competent substantial evidence in the record supporting the JCC's finding that the motion for summary final order was not filed for an improper purpose and that the motion was based on law and fact. The standard of review is not whether the appellant can recite to contradictory evidence in the record in support of a different decision that the JCC could have made on the sanctions motion. As long as the record contains that substantial competent evidence in support of the JCC's decision, the decision is presumed lawful and this court must affirm. Here, the
What
EC
would that evidence look like? Well, I mean, in a sanctions motion context, like, what would we be looking for to make that decision in the first place?
So here, the evidence relied upon by the JCC in finding that the motion for summary final order was not filed in bad faith was the motion itself, the responsive pleading to the motion, the testimony of claimant's counsel. There was an evidentiary hearing held on the motion for sanctions, and claimant's counsel testified as to what he believed the EC knew or should have known prior to filing the motion for summary final order.
And on what grounds did the JCC deny the claimant's motion for sanctions?
I'm sorry, Your Honor.
And on what grounds did the JCC deny the claimant's motion for sanctions?
The JCC found that the motion was supported by law and fact, it had evidentiary support, and that the motion was not filed for an improper purpose. And if you look at the motion for summary final order, it cites on-point case law from this court holding that an employee leasing company is only bound to provide workers' compensation benefits to a claimant if the employee leasing company agreed that the claimant would become its employee in its leasing agreement with the employer. So the dispositive issue in determining whether the claimant is an employee is the leasing agreement that PBS enters into with Oracle. The case that I'm referring to is Crum Services versus Lopez. It's a case the facts are almost directly on point, and this court held the dispositive issue as to whether the claimant was an employee was looking at that leasing agreement. And the leasing agreement said the claimant can only become an employee of the employee leasing company if the claimant filled out the proper paperwork and gave it to the leasing company before it began its employment. And this was exactly the basis of the motion for summary final order in this case, which was there was a leasing agreement. The leasing agreement said the claimant can only be an employee of the leasing company if he filled out the employment packet, the employment application. And in support of that motion, the EC filed an affidavit swearing that the claimant never filled out the appropriate paperwork, and therefore, as a matter of law, the claimant could never be an employee because the dispositive evidence is the leasing agreement, and that there were no other material issues of fact that remained to be discovered in the case.
Counsel, is it possible, though, that the CSE standard goes just one way, that we'd be talking about CSE if your client was the appellant and it was appealing the sanctions order entered against either your clients or the attorneys? Is it possible that the CSE standard would apply there, but not when there's a denial of a sanctions motion, which I question whether
I'm sorry, I'm not understanding you're saying the CC.
The competent substantial evidence standard. It sounds like you're conceding in a way that the claimant does have a right to file a motion for sanctions in the first place, and that we're just talking about whether the judge made the right ruling based on evidence.
No, Your
As
Honor,
opposed to being the judge's discretion when denying a sanctions motion.
we do not concede that their sanctions motion was supported by any competent substantial evidence. There is no law that requires discovery to be fully completed before a motion for summary final order is filed. Instead, the case law talks in terms of, is there any material pending discovery? And the good faith argument that was made by the EC was that although discovery was not fully completed, there was no material pending discovery. And that was based on case law from this court that said when you're talking about whether a claimant is an employee of a leasing company, the dispositive issue is the leasing agreement. And because the leasing agreement was in evidence and supported the motion for summary final order, there were no disputed issues. The leasing agreement clearly showed that the claimant was not an employee.
What if the JCC just summarily denied the motion for sanctions without a hearing at all? Just like you did with the motion for summary final order. It was just a one-liner. The motion for sanctions denied, no hearing. Would that be error?
No, I think the JCC is entitled to deny a motion for sanctions without making requisite findings because the sanctions rule only requires specific findings of misconduct if you're going to impose a sanction.
Right. So why are you arguing consubstantial evidence with respect to the denial of a sanctions motion?
Because when you're looking at the factual findings made by the JCC, the standard of review is was there competent substantial evidence to support the factual findings that were made by the JCC. And here the JCC said, I find that the employer carrier did not file the motion for an improper purpose or for purposes of delay. I find that the motion was supported by existing law, and the JCC also found that the factual contentions in the motion had evidentiary support in the form of 2 affidavits and 2 contracts, the leasing agreement and the independent contractor agreement between the claimant and Oracle, showing that the
Counsel, assuming for the sake of argument that the JCC erred in those findings which you just listed, is there any other record evidence on which we could affirm the JCC, or must we reverse the JCC?
Is there other record evidence to affirm?
To affirm.
Besides the motion for summary final order and the response and the court's rejection of the claimant's counsel's testimony, also within the record was the fact that the claimant voluntarily dismissed. Now, this is competent substantial evidence that the court was entitled to weigh in deciding whether the EC filed the motion for an improper purpose and weighing the argument that there was pending discovery that remained. The JCC was entitled to take into account that even after the JCC denied the motion for summary final order and allowed the discovery to proceed, the claimant voluntarily dismissed. That lends credence to the EC's argument that it was entitled to motion for summary final order because there were no pending material issues remaining to be discovered. And that is supported by the fact that a voluntary dismissal was taken. Rather than obtaining the discovery that the claimant claimed was so material to his case that it needed to discover and saying, I have a valid case to proceed to trial, they obtained the discovery and voluntarily dismissed. And the JCC had the authority and the discretion to take a look at that and decide the EC did not file the motion for summary final order in bad faith, notwithstanding the fact that there was pending discovery that remained. So therefore, because there is competent substantial evidence in the record to support the JCC's decision to deny the motion for sanctions, the decision is presumed lawful and this court must affirm. And I see that I'm 10 seconds away from running out of time, and so if there are no further questions, we respectfully request that the decision be affirmed.
Thank you, counsel.
Thank you.
In rebuttal, Your Honors, if I can make 5 brief points. First of all, in the order that the judge entered, the judge indicated that the only thing he was utilizing to decide this case was the documents. We've cited a case before this in our brief, the Beckham case. It indicates that when the judge is looking at the same documents that the appellate court can look at, it has no superior vantage point than this court does. And all we did was, in our brief, was to argue what the effect of the documents were. Second, in response to your question, Judge Tannenbaum, we filed an evidentiary showing, in addition, as to why the motions for summary final order should not be granted. Specifically, there were affidavits filed by the claimant and by Mr. Schnepper indicating why the motions would have been inappropriate.
Do you think it would have been reversible if the judge had just, if the JCC had just summarily denied your motion without any explanation whatsoever and without an evidentiary hearing?
Well, there was no evidentiary hearing, and he did provide an explanation. Do I think it would be reversible? Well, I think the standard would be then if there's any reason to uphold what he did, because he didn't specify what it was, it would be should be affirmed. But here we know exactly the reason why he indicated it, and he said in denying these motions, discovery hasn't been completed. I take disagreement with Mr. Rogner's position. We never said that discovery had to be completed before you could file a motion for summary final order. You need to understand the sequence of what happened here. These claims were filed in July and August of 2020. In September of 2020, when discovery was propounded, we had to file a motion to compel. We got an order as to Oracle granting that motion to compel, but unfortunately they filed their motion for summary final order without giving us the discovery. We didn't get the discovery by the docket until after the motion for summary final order was denied. So we did not have initial discovery going to the very employer-employee independent contractor issue, because that's what we were after. So we're not saying that this motion could never have been filed and it wouldn't have been appropriate. We're saying that it was procedurally doomed to failure from the start of the time the motion was filed because discovery hadn't taken place. Judge Bilbrey, you asked a question on subject matter jurisdiction. I disagree again with Mr. Wagner. I'm not sure that this is a subject that this argument, which was never raised below, goes to subject matter jurisdiction with regard. This was a claim for workers' compensation. The JCC clearly had subject matter jurisdiction. Anything else had to be raised before him below to establish the propriety of the argument here. Finally, this voluntary dismissal. We had requested, we had requested a protective order against the taking of the claimant's deposition because they produced the discovery the day before the deposition was set. The judge denied the motion for protective order, and we took a voluntary because we didn't have time to prepare the claimant. That's why the voluntary was taken. We stand on the proposition that this motion being procedurally flawed from the start was doomed to failure, which made it frivolous and created the liability for attorney's fees under Rule 6.120(4). We respectfully request you reverse and remand it back for a determination of fees. And as always, I thank the court for the opportunity to appear live.
And thank you, counsels, for your respective oral arguments.